some key takeaways for all participants regarding the basics of copyright and copyright compliance. More specifically, you should be able to indeed be given a recap of basic requirements for copyright protection, the main rights granted by copyright, and then how to avoid infringing third-party copyrights. So this is something that was also covered in previous webinars, but since I understand that only half of the participants attended those, it might be useful indeed to provide this basic information.
Eleonora, I'm sorry, we are not seeing your share screen. It's small. We are seeing.
Yes, you can click on slideshow.
So let me try to redo it. Apologies for
that. Of course. You can go to slideshow.
Now you should be able to see it.
Great. Thank you very much.
And then I will be discussing 3 case studies that serve indeed to bring to life the concepts that are inherent to copyright law. So let's get started with the basic requirements for copyright protection. It has to be said that the law might be different depending on the country whose law you need to comply with, but there are some principles that more or less are the same no matter where you are based. And in essence, I'm referring to 3 key requirements. The first one is that copyright only protects works and not ideas per se. So this is a basic principle of copyright law and it is found worldwide. The second is that there must be an author, someone who has created the work, and generally speaking, most jurisdictions around the world posit that the author must be a human person. There are some exceptions to this rule, and these indeed are relevant in the context of company copyright, as well as in the context of works created by artificial intelligence. Third requirement, the most important one in practice, is that a work will be protected by copyright if it is sufficiently original, meaning it is the result of free and creative choices of its author. Then, depending on the country where you are based and the law you need to comply with, there might be additional requirements. This is true for works of applied art, also known as designs, and it is true indeed having regard to certain country requirements, such as the requirement of fixation or requirement of categorization. But bottom line, the 3 requirements that I've mentioned, work, author, and originality, are present no matter where you operate. The other thing is that copyright, unlike other rights, arises automatically. So you don't need to register anything. Sure, there are some countries where registration is highly advisable, one such example being the United States, but protection arises irrespective of any formalities, and also if you are considering the use of the copyright or C symbol, that is something that might be useful to give an indication of who the perceived copyright owner is, but technically is not required for protection to arise. So you should not be thinking that if you don't use the copyright symbol, your work is not protected, nor should you be thinking that if someone uses the copyright symbol, for sure they have any rights over that material. This is a basic but important notation. So, given that copyright arises automatically, it also comes with a set of rights. And these rights belong to 2 main families, economic and moral rights. Let's start with the latter. Moral rights relate to the personal connection between an author and their work. They are more strongly protected in jurisdictions where historically copyright has been seen as a natural entitlement of the author, an extension of their personality, but they are also mandated on an international level. So most jurisdictions around the world recognize stronger or weaker moral right protection. There are 2 moral rights that are mandated at the international level. The first one is the right of attribution, also known as right of paternity in some older text, and it is in essence the right to be credited as the author of a work. Then there is the right of integrity, that is the right to indeed safeguard the integrity of a work and object to any distortion, mutilation, alteration of said work that might be prejudicial to the honor or reputation of the author. Example, turning a novel into a pornographic film is likely to be something that the author of the novel can object to, inter alia on grounds of indeed their moral right of integrity. Then there is the group of economic rights, which relate, broadly speaking, to indeed the possibility of exploiting economically a work. And these rights have been harmonized to a greater extent, and insofar as the European Union is concerned, I would say that they are mostly harmonized. So if we take the basic right under copyright, that is the right to make copies of a work, and if we look at this right in Portuguese law, Italian law, Finnish law, etc., the scope of protection will be the same, because all these countries are members of the European Union, which has undertaken the harmonization of the scope of protection. So, to recap, the main rights under the family of economic rights include the right of reproduction, that is the right indeed to make copies of a work, and that is in essence why copyright was born historically. Then there is the right to sell copies of this work, and that is the right of distribution, the right to communicate a work to the public. We can have different types of situations. If you watch a film on Netflix, that is a situation in which the right of communication to the public comes into the picture. But also, if you go to the theater and you watch a play being indeed performed, that is also an instance of communication to the public. So this right covers both instances of on-demand and not on-demand, indeed, communication. Then there is the right to rent or lend copies of a work, and that is, for example, what libraries do. Then there is the right to perform, show or play the work in public, which is a part technically of the broader communication to the public work. The right to make an adaptation of a work, for example, turning a novel into a play. And indeed, all these rights are more or less the same across the various EU member states. And also international, they've been harmonized to a much greater extent than moral rights. So, bottom line, depending on the jurisdiction you operate in, you will need to be aware of the relevant nuances and specific requirements, but roughly speaking, all these concepts that I've expressed are indeed treated similarly. So, copyright arises automatically. It has a rather long duration. In Europe, the duration is life of the author and 70 years after their death. So, the question that arises is how you make sure that you are not infringing someone else's copyright. And this is the topic of indeed compliance. So, first things first, who owns copyright? So, in essence, who should you be asking permission from? And here the answer depends on indeed the copyright ownership of a work. So, the basic rule is that the author, the creator of a work, is also the first owner of the copyright. But indeed, the copyright can be sold like any property. So it might be the case that an author has transferred their copyright to someone else. And there might be situations in which the author is not the copyright owner at the outset. For example, there are laws, such as in the UK, in which if the author is the employee of a company, is not the first owner of the copyright, their employer will be. And then there are countries like the US where there are doctrines like work for hire, in which indeed the author is not deemed to be the owner either. So in order to look into who to ask permission from, first thing is to identify who the copyright owner is. In all of this, one should be aware that not all rights are treated alike. So while it is possible to transfer economic rights, so I can sell my right to make and sell copies of my article to a newspaper, there are rights such as moral rights that cannot be transferred. They are personal right of the author. So depending on what rights are at issue, you may need to have to ask different subjects for permission. Then, when we speak about compliance with copyright law, we have two main situations. The first one is one in which you ask for permission, and this permission is given to you in different forms. The most straightforward one is a license. That is a permission to carry out an activity restricted by copyright. You ask for permission to reproduce someone's photograph on your website, and this person grants it to you. It is not that you have acquired the rights over that photograph, but you have been authorized to undertake an act of reproduction and an act of communication to the public, which are indeed the prerogative of that copyright owner. So when we speak about contracts, we can have licenses that are permissions to do something and can be in different forms. A license can be simply oral, can be in writing, can be exclusive, non-exclusive, transferable, non-transferable, time limited, perpetual, limited to certain countries or uses only, or indeed covering the entire world and all possible uses of a work. So this consent can be shaped in different ways. Another type of contract is a transfer or assignment of copyright. So in essence, the owner of that copyright sells their property to someone else. As I mentioned, it is possible to transfer economic rights, but there are rights, in particular moral rights, that cannot be the subject of these transfers. So one way to indeed bypass this limitation is to include in these contracts a waiver that is an obligation that the author does assume on themselves not to enforce their moral rights vis-à-vis the counterpart in the contract. So that is the first option. You ask for permission and you conclude a contract. The other option is that you may not need to ask for permission because an exception does cover your intended use, and indeed the law does protect you against any claim of infringement. Let's exemplify. If you want to provide a short quotation of someone's novel in your on your website, in principle, you would be able to do that without asking for permission, because most countries around the world do recognize an exception for quotation. An exception that is subject to a number of requirements, but in essence is there to safeguard your freedom of expression. Same thing, if you want to make a parody of someone's work, under most countries' laws, you will be able to do so, subject to a number of requirements and with certain limitations. So, to conclude, if you want to comply with someone's copyright, first thing is to identify who you should be asking permission from. And this might be quite a daunting task in some circumstances, including where you have multiple authors or you have complex works that incorporate indeed a number of smaller works. Take the example of films or music videos. They indeed come with multiple right holders. Then option 1 is to seek for permission, so to conclude a contract, and option 2 is indeed to rely on an exception, so without the need for permission. So how does that play out in practice? As I mentioned, I will be providing 3 case studies. The first one is that you need permission for things that are protected. That might seem basic, but in practice gives rise to more than one headache. Let's take the image that you see on the right-hand side. Since many of you represent cultural heritage institutions, they will be familiar indeed with the practice of digitizing museums' collections. This is taken from the website of the National Portrait Gallery in London, and it is a digitized image of a painting that is no longer protected by copyright. So the underlying painting is technically in the public domain. But as you can see, the museum does claim that it has a copyright over the digitized image. Is that a valid claim? Perhaps not, because indeed, as I mentioned, for copyright protection to arise, it is necessary that a work is original. And if you want to make a faithful reproduction of a work, as it has been done here, perhaps the author of the digitized image has not exercised sufficient originality. So a claim that this object is also protected by copyright might turn out to be untrue. If that is so, technically there is no copyright to exercise because of lack of the relevant requirements. Now, what I've said is likely to be accurate, but it is a topic that is rather contentious and there are different views in this respect. The message that I want to convey is that not necessarily something that is claimed to be copyright protected actually is. And then there is the topic of AI-generated outputs. On the left-hand side, you see two images that were at the center, indeed, of actual cases. The first one was at the center of a Chinese litigation, while the second was a work created with AI that the US Copyright Office decided to register. I've chosen these two outputs because through different mechanisms, in the end, they were both considered protectable by copyright. Why? Because the respective authors were able to show that they used AI as an aid, so it was not something purely AI generated. But as you understand, if you were in a situation in which the AI did everything on its own without any creative input on the side of a human author, then the resulting output, an image, a text, piece of music, and so on, will perhaps not be protected by copyright. So the first message is the following. Only things that are protected by copyright or rights related to copyright are indeed within the scope of copyright compliance. So both on the side of those who claim to have copyright and on the side of those wanting to use these outputs, the first question that should be asked is this actually protected? Now, moving on to case study 2, and it is indeed the topic of contracts. And here I've selected a couple of examples to show to you that first, when I give you permission to do something with my copyright work, I define the scope of my permission. So that means that you need to fall within what I've allowed you to do. And if that is not the case, there might be a copyright problem. Let me exemplify by reference to the licensing terms of the journal article that you see on the left-hand side. Now, I imagine that many of you will be familiar with Creative Commons licenses. They are quite a straightforward and widespread type of license that in essence has the advantage of allowing the copyright owners to inform third parties at the outset what can and cannot be done with their work, so without the need for individual contracting and licensing. So this article was licensed under a Creative Commons attribution, non-commercial, non-derivative license. What does that mean? That these are the things that are allowed. You can use the article by providing attribution as to who the author is, You can use it for non-commercial purposes, and you cannot make derivative works. If vice versa, you sold the article, that will be a commercial use, so it will be outside the scope of the permission. So the message is, first, if you have a license, check the scope of the license, because only what is within that scope is what you are allowed to do in relation to that work. Second example, on the right-hand side, here we have a different type of contract. Indeed, it is not a license, a permission, but it looks like a transfer. So the author is assigning to the publisher the rights to exploit their work. If that is what happens, and if the author agrees to that, in turn, that means that the author will no longer be entitled to exploit the work on their own. They cannot sell copies of their work without the permission of the publisher. Technically, they cannot even make a derivative of their works without the permission of the publisher. So, also when signing a contract, do check what you are actually agreeing to, because indeed the effects and implications can be well different. Final case study, exceptions. As I mentioned, these are situations in which you don't need permission. But of course, the devil always lies in the detail. And here we have three situations that I would say look quite similar, and yet the outcomes have not been the same. So the one that you see on the left-hand side is a well-known US case in which a photographer, the one that authored the photo that you see on the left-hand side, did sue an appropriation artist, Richard Prince, for indeed using his photograph without permission and adding indeed the blue elements that you see as well as the guitar. The claim was indeed the copyright infringement. The conclusion was no, this is covered by an exception, in specific the US fair use doctrine. So in this case, the appropriation artist was found liable for copyright infringement. Then on the right-hand side, you find examples from Europe. Let's start from the sculpture on the lower right corner. So this is a sculpture by Jeff Koons, another famous contemporary artist on the verge of appropriation art himself, who was sued by a photographer for indeed infringing his copyright in the photograph that you see on the left-hand side by making the sculpture that you see on the right-hand side. I would say that this situation looks, on the face of it, quite similar to the US case, but this case was litigated in France under French law, and the conclusion was that this was a copyright infringement. So here, Jeff Koons was found liable. In the US case, Richard Prince was found not liable. And then to conclude, on the top right corner, you find an example of a Belgian case which was settled out of court in the end, so there was no judgment, but in which indeed the estate of a comic book author sued a political party for indeed infringing the copyright in the cover of the book that you see in the slide. The defense raised by the political party was that this was not an infringing activity because the use would be covered by the parody exception. And a question was raised to the EU Court of Justice asking indeed what parody is. In the resulting judgment, the court did indicate the elements of a lawful parody, but also specified that if the parody is discriminatory in its content, as it seems to be the case here, because as you can see, the people receiving the money from the benefactor were replaced by people of color, people wearing a veil, and so on, then this use should not be allowed without the permission of the author. So in essence, in this case, the Court of Justice did seem to suggest that a use of this kind should not be regarded as a lawful parody. So to conclude, also mindful of the time, I would say that copyright is an important, absolutely free and extensive set of rights. The scope is quite broad, and so is the duration. But when it comes to copyright compliance, there are indeed various aspects to consider. The first one is whether indeed the object in question is actually protected. And here I've referred to copyright, but you should not think that copyright is the only thing that matters. There might be related rights, there might be rights in personality, there might be aspects relating to protection of privacy and data protection. So first thing is that you can indeed exploit and control what is actually protected. Then in the main bifurcation that I've illustrated, permission and no need for permission, insofar as the former is concerned, permission, one, do check out what one is consenting to, what type of contract they're entering into, and second, what is the scope of the consent that has been given. Turning to the latter, that is unlicensed uses, uses that one does undertake, thinking that an exception will cover indeed their activities, I think that it is important to bear in mind that despite the similarities in most of copyright concepts, there are significant differences that still subsist, and a lot depends on the circumstances at issue. So you should not be thinking that because the outcome in a certain case was X, that also your situation will be treated like X. It depends on indeed several factors, and also that depending on indeed the country, the copyright law you need to comply with, you may need to think about different factors, and you might have different outcomes indeed to achieve. So with that, I hope that I've offered a somewhat helpful recap of what was discussed regarding the basics of copyright protection, and that the case studies served indeed to add some flesh to this structure. Now I'm very happy to take any questions that you might have before giving the floor to my fellow speakers. Thanks a lot. I cannot see anything in the chat, but if someone wants to raise a question either in writing or by unmuting themselves, I think that's absolutely fine. Thank you.
Of course. Thank you, Eleonora. If there is any question, we can address it right now. Otherwise, we can discuss everything at the during the Q&A part. Thank you very much for your perspectives, Eleonora. We can move with to the second expert, Konrad Gliściński. You can share your screen if you wish.
No, hello. Thank you very much for having me here. I will try to do it without sharing the screen, as it may be the idea is to make a main recap of what I said previously, but I also want to build on what was said just before by Professor Rosati, because when it comes to understanding how cultural heritage institutions like museums, libraries, galleries and things like that, or other researchers, they want to use protected materials, they really need to go through the process which was called compliance, but also can be called a right clearance. We need to understand what types of things we possess in our collections and how we can use those things. And to do it, of course, we need to do this process which is called right clearance, which in basic require those kind of institutions to gather a lot of information which are needed to answer the question if I'm able to use particular work. Why is it so? In copyright, as it was mentioned, you have at least 3 possibilities to share your works which you possess as institution. First of all, you can be an owner of particular copyright. It is possible if you are an institution which develops some kind of works like books, posters or your own activities. Probably you have your own copyright to that, and you can somehow use it quite freely. Second of all, if you are not in that position, of course, you may acquire those rights from other people by transfer agreements, as it was mentioned, or by licensing agreements. This is a very vast topic, because the rules how you acquire the law, how you acquire the rights to the objects which are based on work of your employees or your contractors can vary from country to country. So you need to understand how this mechanism works in your country, in your legal environment. The same story goes with the transfer agreements and the license agreement. The basics is exactly that. If you enter into a license agreement, if you have a transfer agreement, probably you will be able to use the works, but it also depends what is put in those agreements, because there is nothing. In copyright, this is a situation in which you can have a very broad license agreement or very narrow license agreement. So there is no such a thing as one size fits all situation. So all the time when you discuss if you can share some kind of material, you need to go in a very detailed analysis of what you possess on what basis. And if the contracts is not the option, of course you can go to the exceptions and limitations, and this is the other possibility. But once again, when it comes to exceptions and limitations at the international level and also at the level of European Union, we have quite broad harmonization of rights. Okay, so exclusive rights are more or less harmonized, and in more or less countries we have the same types of rights which are granted to the author, to the owner of the copyright. But when it comes to exceptions and limitations, unfortunately, we have very weak way of harmonizing them. And when it comes to those exceptions, they can vary from one country to another. As you probably know, at the European Union, we have the basic directive in this realm is, of course, InfoSoc directive, and there is a very famous list of exceptions and limitations. This is not the only exceptions and limitations which we have in our copyright, but those are the most important and the most famous one. But when it comes to those exceptions and limitations, you need to understand that each of that exception and limitation is except one, are optional, which means that the country can introduce those exceptions, but they are not obliged to do it. And this is the normal case scenario. In most case scenario, countries did not go to introduce all of those exceptions and limitations. And what's more, when it comes to the manner how those exceptions and limitations are implemented, they can also vary from country to country. So in one country, the quotation could be this type of quotation allowed, and in another country, the right of quotation could be totally different. We are now currently wrapping up our research on research exceptions, and we create an index, and we try to measure how particular exceptions and limitations vary from one country to another, because those differences are quite vast. And when it comes to using the works and sharing the works in your environment, if you want to share this online with your with broader audience, but also when you want to share those collection with some kind of consortium when you are doing your research, it can create a lot of problems, because you can find out that some types of activities are allowed in one country and another are not, and they are not allowed in another. So at the end, you have also additional possibility if you are not in the position to use work based on contracts or work based on exceptions and limitations. Then maybe you are, as a collector, as an institution, maybe you possess some kind of objects which are in public domain. The concept of public domain is quite vague, and of course we can have a lot of definition, but in a nutshell, the things which are in a public domain, there are the things which are never protected by the copyright, like very old things, but also you can have the works which came into copyright because of the time lapse of the protection of the particular object, and also those type of objects which are not protected by the copyright because of they are not a work from that perspective. And when it comes to copyright and when it comes to right clearance in the realm of public domain, once again, we can face a lot of problems. So first of all, we have our directive, which this is a term directive, which gave a general framework how long the copyright works and how long does it takes to expire. And of course, when you have all the information about particular object, you probably can understand if it is protected or not. Because if you know who was the author, if you know when the work was published first, when you know from where the authors come, and when he died, all those information are the basic information which helps you to solve this conundrum if work is in a public domain. But the problem starts when you have anonymous works or when you have an author which you don't know from where he came, or you don't know how all these particular objects. A few days ago, we have this kind of extensive workshop with museums, and they show us their collections of photos, their collections of other artifacts, and we try to figure it out if they are or are not in copyright. In copyright, it was quite difficult, and I would say that this is the most important problem in this area, is to be able to possess those information. Okay, because first of all you need to know what types of information you need, and second of all you need to gather those information. In many case scenario, it was impossible because the institution, even they possess those objects for many years, they just simply don't know. And it's, of course, opened a lot of problems. Of course, in copyright, we have some types of institutions which helps us from time to time to solve those problems, like, for example, Orphan Works Directive or out of commerce work. There are those institutions which you may try to use in particular context, and from time to time it will be possible. But as we discussed in our webinar, and our first webinar, there are those types of, for example, implementations of those instruments, which makes it impossible to use them in practical terms, or because there was some kind of a mistake done by the implementation process, which is a case of Poland, or, for example, in a situation when everything was implemented correctly, but when it comes to out-of-commerce work, organizations which are responsible for issuing the license just refuse to do it. So there is an instrument, but if there is a refusal to issue the license, we are in a pickle. Okay, but this is one layer of the problems, and the big problem of it is, of course, that you need to find out what types of information you need to gather those information, and in many case scenario you will need to chase those information. If you decide not to do it, of course you can make some kind of general rule of thumb decision, in a sense that if you have something very, very old, probably it will be not protected by copyright, and maybe you will be able to use it. But this is also not always the case. As you know, copyright, it is only one layer of protection of particular materials when it comes to collections which are held by institutions like museums, archives, libraries. We have also other layers of rights which come into a power or come to our discussion. And of course, the vast majority, they are called neighbor rights. And those rights are like performers' rights, right to phonograms, right to videograms, right to program broadcast, database rights, and so on and so forth. Then you have also another element of discussion, which is, of course, right to privacy, because when you possess some kind of object, which is also, which could be the problem to share this particular object because of the right of privacy or other ethical consideration. Why I'm saying it is because when you think about the right clearance process, you need to understand that there is the legal part of it. So you need to know what you need to know, what types of information you need to gather to go through that process. You also need to go through that process, but also you need to take into consideration two other stuff. First of all, you will be in a many case scenario in a situation that you will not overcome those kind of a lack of information. And then there is a place for your institution to create something which is called risk assessment, which is additional instrument near to right clearance. But this mechanism is based on understanding of what types of objects we have and if it is really danger to share them with other people. You make, and then you as an institution, you need to make a decision. If you are aware of, for example, situation, okay, I know that I'm not able to gather all those information, so maybe my right clearance process is not ironclad, but because of the types of this particular collection or types of this particular objects, I can share them quite freely or quite safely, because I suppose it will not create any harm. But on the other hand, you can, as an institution, make a very strong statement, and we know those institutions which possess this kind of statement, that we are a public institution and we will only operate in a situation in which we know everything. If we don't know everything about particular objects, so we will not share those information and we will not share this object with other people. What types of institution you are and what types of risk appetite you have is, of course, different, and I cannot help you in that. But what is important is that it would be very advisable to produce something which is called a policy of management of intellectual property in your organization, and then try to understand which types of risk you want to take and which types of risk you don't want to take. And I want to go back to this old stuff problem. Why is it so? Because from time to time, we in copyright say, okay, if something is very, very old, like, ancient things, probably they are not protected. But there are countries which create additional layers of protection for unpublished works. And those kind of situations can end up in also in a court scenario. There is a very famous case about the Nebra disc, which is very ancient, but as was claimed by one of the German state, it was photographed first and made published first by this state. And by doing it, they acquire additional layers of rights. So in each of those kind of situation, you can end up in an information when you realize that there are lots of different types of exclusive rights. And if you not create a very thorough right clearance process, which will be supplemented with this risk assessment management tool, then probably you'll be in a very problematic situation. Because of course, if you know everything, because for example, you have a book, you know the author, you know the publisher, you know when it was published, then it's easy to you. But if you have a collection of photographs, if you have very old piece of costume design from the 19th century, if you have unpublished manuscripts or lists or things like that, then then the situation became more and more complicated. And of course, you need to also remember that because of the principle of cumulative protection, one particular object can be at the same time, to a different extent, protected by different layers of IP protection. So there could be a copyright, there could be a related rights, there could be additional things, and you need to take all those things into consideration if you want to do it legally accessible. And this is an element in which I want to wrap up and just say what I'm saying is quite overwhelming, but it means that you need to really go through this exercise if you want to make this compliance about particular object, which was mentioned by Professor Rosati before. It is manageable. There are institutions which are able to do it, but if you are a small institution, of course, you need to figure it out how to approach these problems. Thank you very much.
Thank you very much, Konrad, for your perspectives. Do we have any question at this point? Okay, we can move to the third part, collective licensing. Anthi, Akritidou, the floor is yours.
Thank you very much. Let me just try to share my screen. I believe you can see my screen now, right? Okay.
We can see your screen and hear you very well.
Excellent. Thank you so much. Good morning, everyone. First of all, I would like to thank the organizers for the kind invitation to have me once again here at the very last webinar of this series. So for those of you that probably did not follow my presentation during the first webinar, I am Anthi Akritidou. I work at the International Federation of Reproduction Rights Organizations, the so-called IFRO, which is based in Brussels. So in a nutshell, IFRO is an independent non-profit membership association. What we do is that we try to facilitate on an international basis the collective management of reproduction and other rights when it comes to text and image-based works through the cooperation of our member collective management organizations, which can be also called reproduction rights organizations, so CMOs, that administer copyright and related rights in the text and image-based works are called RROs. Nearly all RROs on an international basis are members of IFRO. We have 160 members. Some 130 of them are RROs from some 90 countries, and we have as members author and publisher organizations as well. I can see that some of our members are online and have joined this webinar. So our members represent many millions of authors, visual artists, and publishers of books, journals, newspapers, magazines, and printed music. We heard an excellent presentation by Eleonora. She gave us the framework before, and one presentation by Konrad before on the exceptions. So I will basically talk to you about the rule right now, because the word itself says that we have talked about exceptions to the rule. So while it was a little bit unorthodox, I promised to provide you with some interesting data during my presentation. When we talk about using copyright protected content in general, the key rule is very simple. We heard of it already. Assume you need permission. That permission usually comes from the author, the publisher, or any other rights holder. CMOs administer the rights on their behalf. So the CMOs might provide you with a license. There are two only main exceptions to this rule. We heard them before, when a work is in the public domain or when the law provides a specific exception or limitation. These are the only cases under which you don't need to get a permission, a license. We need to remember that copyright exists as well as related rights, exist to reward and sustain creators and publishers. Without proper licensing and remuneration, the creative and cultural sector, and industries as well, cannot continue producing the high-quality works that we see nowadays. So in practice, the safest approach is to start with the assumption that you need a license unless you're absolutely sure that the work is free to be used under the law. Let's now move a little bit to the educational sector. And what about the educational institutions? Do they need licenses? Can they rely on exceptions and so on? One of the realities right now in education is that the simple course books that are given to the pupils, to the students, or university students later on are not always enough. Teachers often need to bring a wider, we would say, variety of resources. They will distribute some parts of articles, book chapters, maybe magazines, and so on, in order to keep lessons relevant and more engaging. But that diversity of material is also what makes the learning experience more interesting. Let's now move to the legal side. When you use those extra materials, as long as they are copyright protected, in principle, that means that you need a license in order to use them in class or in a digital classroom for the use to be lawful and for you to be secured. Many people would ask, what about exceptions? Can we just rely on exceptions under copyright law? So the challenge is that exceptions, as we heard before, are not harmonized across the EU. And where they exist, they should be interpreted very narrowly. So what's allowed in one country might not be allowed in another country. And often exceptions won't cover the full range of teaching activities. For example, in some countries, you might only be allowed to use a 5% of a work under the exception, but if you get a license, the margins there are quite increased. You might get up to 20% of the work. Also, exceptions often exclude entire categories of works. So, for example, in Germany, the sheet music is not included, is not allowed under the exception. That means that if we have a music school, then the teachers will need to get licenses in order to distribute to their students sheet music. Another important point would be that if a license exists in some countries, it can override the exception. That means that when a license is available, the exception remains, let's say, inactive. And that's why licensing is so important. It provides legal certainty, it supports the creators and all rights holders, and it is, of course, the safest option for schools and universities, but for all educational institutions in general. One of the questions usually being raised is if schools and educational institutions do take licenses. According to the data that we have collected from the IFRO community and our members across the world, yes, we see that schools and universities across Europe, since this is the most important part for this webinar today, do take licenses, sometimes from collective management organizations and sometimes directly from rights holders. We have already mentioned the term license quite a few times so far. So what is a license at the end of the day? The previous speakers already gave you an idea of this. So if I can make it a little bit simple, at its core, a license is a legal agreement between the copyright owner and the user, the educational institution in this case. It sets out how a protected work can be used, where, for how long, and under what conditions. The important thing, as we mentioned already, is that it ensures creators retain control over their work while enabling at the same time authorized uses. There are different kinds of licenses. Eleonora referred to them already: exclusive, non-exclusive licenses, and so on. I will focus on the following distinction when it comes to types of licensing. So the direct licenses and the collective licenses. Direct licenses come from the author, the publisher, or any other rights holder that has the rights to do so. and it is often specific to a particular use case. So for example, think of a teacher that would like to take a permission to use a certain book for a particular project. This might turn into a little bit impractical, because imagine if the school needs more than one books. Then it needs to identify all the different rights holders, and then needs to approach them to take the licenses. So this is where collective licensing can help. Collective management is managed by collective management organizations. These provide blanket licenses that cover a wide range of works and uses. And this is especially useful, as we just mentioned, for the educational institutions and the sector in general, because it saves them from having to negotiate individually with multiple rights holders. Another point to note is that licenses often evolve with technological advancements. We can see that the collective management organizations adapt to the technological developments. They are not static. So today, these licenses can cover not just printed materials as in the past, but digital uses as well, which are very relevant for teachers. These licenses cover, of course, teachers, students, and educational institution staff. So which uses require license, and how do these work in practice actually? The licenses, as mentioned, are negotiated between the two parties, the RROs, the collective management organizations, and who represent, of course, the authors, publishers, and other members, and between the ministries or federations that represent universities and schools in the education sector. These licenses are not one size fits all. They are tailored to the needs of different education levels. We have, of course, different needs in the primary sector, secondary sector, and higher education. And they also take into account the ways teachers actually work, both with the traditional and digital tools. But what do these licenses usually cover? Well, quite a lot, as you can see on my slide. Teachers can scan, photocopy, print content, copy from books, magazines, online sources, insert text and images into presentations, distribute content digitally through platforms that are secured. So when you have a digital classroom that is secure with passwords and so on, and they can even store downloaded materials securely on the institution's intranet. There are limits, of course. For example, prompts for AI tools are not covered under current licenses. However, I'd like to note that just a few days ago, so earlier this week, our Danish member received a mandate from its board in order to begin negotiating licenses for the use of text, images, and other printed material in AI tools, both in the education and the commercial, the business sector. So we'll have some more developments in this area. These licenses also apply across different environments, as I mentioned, physical classrooms, virtual lessons, and cross-border education scenarios, of course. Here, I will not stay for too long here. This is a scheme that you can also find on our website. I have the link at the end of my presentation under the section Content for Education, and it shows a little bit how collective licensing works in this area. Licenses are quite broad in scope. They don't just cover national works. They extend internationally thanks to bilateral agreements between the different collective management organizations. This is, of course, made possible through the mandates that these organizations take from authors and publishers in order for their works to be included in these agreements. But how much can someone actually use under these licenses? Well, this differs across the different countries, of course. We are talking always about extracts of works, not entire books, magazines, and so on. If you want to use the full book, you need to get direct permission from the rights holders. Typically, licenses allow copying from 5 to 20% of the work. For example, we have seen 5% in Ireland, but 10% in higher education, 10% in France, 20% in Denmark and Finland, And when it comes to out-of-commerce works, in some cases, that percentage can be even more increased. In practice, many licenses allow one full chapter of a book or around 20 pages, even if this exceeds the percentages that I have put on my slide. For example, in Denmark, we have seen for universities that the license covers up to 50 pages from a work. And I must note here that even when you're covered by license, it is essential to always credit the source and the author in order to show respect to the creators of this particular work. Now, when it comes to fees, there isn't a single approach, there isn't a single fixed model. Instead, licenses can be structured in different ways. Sometimes they are calculated on per page, let's say, copies per page, sometimes per student that is enrolled, and in other cases through a lump sum agreement that covers everything for an institution, basically. These are not arbitrary. They are tailored to local conditions and actual use. So normally collective management organizations carry out surveys in order to understand what and how much is being actually copied in education. Educational institutions are asked to make annual declarations. They provide the number of the students enrolled and the average number of copies that are being made during the year. The reporting is done through digital platforms or in analog ways. So our big takeaway from here is that licensing fees are built on transparency. As I mentioned, they are not arbitrary, but they reflect the real usage. They adapt to different educational contexts, and they assure a fair balance between, of course, the creators and access for schools and other educational institutions. So here are my final remarks. I think you have heard me talking about this maybe 10 times by now. In general, the use of copyrighted material in education requires prior authorization. While certain exceptions exist, they are often narrowly defined, inconsistently applied across the EU because of the lack of harmonization, and frequently open to interpretation. So what do you need to do? First of all, check with your educational institution to see which licensing agreements are already in place, and consult your national CMO, RRO, and their website in order to ask for further guidance and information. If you visit your national CMO's website, a lot of this information is already public there. For example, in France, you can already see the agreements that they have concluded with the ministry and the Federation of Universities and so on. And I have also put here our website, Content for Education, where you can find some more information. Thank you very much for your attention, and looking forward to the Q&A part.
Thank you. Thank you very much, Anthi, for your perspectives. I can see that there are some questions in the chat, and they have been answered by Eleonora, Rosati. We can move forward with the next presentation, use of copyrighted materials, and we welcome Bartolomeo Meletti.
Hi, thanks, Daphne. Good morning,
Thank you,
everyone. Can you see my screen?
Of course, we can see your screen and hear you very well.
Good. Right. So, hi, everyone. So I thought, I am aware I'm one of the last speakers and you already received quite a lot of information this morning. So I thought that, during this presentation, what I could do is to connect to some of the things that have been said, and rather than give you like an awful lot of more additional information, try to apply, some of the things that have already been said and discussed. And I'll do that with the goal of basically trying to, explore together the thought process that one needs to follow when dealing with copyright issues. So the different steps, how to think about, a copyright question, basically. And yeah, in that spirit also, I like this to be as interactive as possible. I mean, I see that some of you are already asking very interesting and complex questions in the chat. So I would encourage you to keep doing it also during this presentation. And hopefully, that then will lead naturally to some key takeaways at the end of the presentation. So to do that, I thought I would start from 3 examples that I used in one of the previous webinars, the one for cultural heritage institutions. I used these 3 photographs you see here on this slide, which I found on the Europeana website. So many of you will know, Europeana is a mass digitization initiative of the European Commission and offers a website where you can find over 60 million items provided by thousands of European cultural heritage institutions. And as you can see below each of the pictures, they come with labels that indicate the kind of legal or copyright status of that photograph. Or other item. I mean, there are also other things, not just photographs. And I thought, they were interesting because what we're looking here are 1 painting and 2 sculptures and their digital reproduction. So, we're not looking at the actual thing, we're looking at their digital copy. And as you can see, each of them comes with a different label. And I think, that's an interesting example to think about what is usually the first step when thinking about any copyright issue. Whether you are creating something or you want to use an existing material, the first thing you need to do from a copyright point of view is to establish a subject matter. As Eleonora explained earlier, you need to understand whether what you're dealing with is protected by copyright or not. And to do that, in these cases, basically the key pieces of information you need, again, as said by previous speakers, is that under EU copyright law, something is protected if it's considered the author's own intellectual creation, and if it's considered that if the author have made free and creative choices. So there must be creative choices involved, not just technical choices. Another important piece of information to establish it in that example is what has been mentioned again about duration, that copyright usually lasts for life of the author plus 70 years. That's the case for artistic works. So those 3 things we're looking at, statues and paintings, are artistic works. So we know that they will be in the public domain if their author died more than 70 years ago. And then 1 provision, which I'm not sure has been mentioned yet in European copyright law, is Article 14 of the Copyright and Digital Single Market Directive, which says basically that if a work of visual art like those we looked at are in the public domain, their copyright has expired, then any material resulting from the reproduction of that work is not subject to copyright. So the kind of things you're discussing in the chat, whether a photograph of a public domain painting or other object can attract copyright and or related rights or not, well, the directive in 2019 said, no, it doesn't, unless the reproduction itself is original. So with that information, then if you go back to the 3 objects, so we have a straightforward case on the left-hand side. So that's the famous Milkmaid by Vermeers, well in the public domain. Vermeers died in 1675, and is also marked as public domain. So again, from a copyright point of view, if you look at this through a copyright lens, here you're looking at potentially 2 works. You're looking at a photograph, which in certain cases attract copyright, and you're looking at a painting portrayed in that photograph. Well, here, both the painting and the photographs are in the public domain. So based on Article 14, the law tells us that a faithful reproduction of an out-of-copyright work of visual art is in the public domain. The Rijksmuseum, unlike the National Gallery, as Eleonora showed earlier, recognizes that, and basically the Rijksmuseum policy is in line with the law by not claiming copyright. They just mark it as public domain. So that's straightforward. The second one, the one in the middle, is slightly more complicated. So here, one of the complications is one of the problems that Konrad mentioned earlier, is that we don't know much about the sculpture in the photograph. All the information you can find on the Europeana says it's a statue and estimated to be made between 1910 and 1914. So it could well be in copyright, if the sculptor was a young sculptor who maybe died 50 or 60 years later, it will still be in copyright. But then, in this case, the photograph is different. As you can see, it's not just a faithful reproduction, it's a photograph that includes the object plus some background, and there are creative choices there, I think, fairly clearly, like the angle and so on. The photographer, which is also credited, Andreas Lechtape, made some free and creative choices. So I think in this case, they are right to claim that the photograph itself is in copyright. We don't know about the statue, but the photograph of the statue is in copyright. And then finally, the third case is a slightly trickier one because it's again a sculpture, The Expulsion by Henry Wiles. We don't know that in Europe that's in the public domain because Henry Wiles died in 1930, so more than 70 years ago. But so what you're looking here is not, that's a screenshot, but it's a screenshot of a 3D model. So that's a 3D scan. It's not like a 2D photograph. It's a 3D scan. And so the debate that Eleonora mentioned earlier about, whether a faithful reproduction attracts copyright or not, here reaches a slightly higher level of complication because, in a 3D scan, there are more choices to be made. It's a more technical process. Some may claim there are some creative choices. Others argue there aren't. So I think, many experts argue, for example, that again, the kind of reasoning is the same you should follow for a 2D painting. If like what you're trying to achieve is a faithful reproduction, then that's more of a technical endeavor rather than a creative one, and so it should not attract copyright. But in this case, the Fitzwilliam Museum distributes the scan under a Creative Commons license, which presupposes that the work is in copyright. Because if you distribute something under an open license like Creative Commons, the basis is that what you're distributing is protected by copyright, but you are deciding to distribute it openly. You're giving permission to everyone to use it, but again, you're entitled to give permission if the thing is protected by copyright in the first place. So is the Fitzwilliam Museum entitled to do that? Well, that's debatable. Many would say no, they should just put a public domain mark like the Rijksmuseum did with the milkmaid. But really, the point I'm trying to make is not really that, what's right or wrong. It's more about the fact that, copyright law really shapes quite a lot of your decisions as a cultural heritage practitioner, but also as an educator or a researcher. But, within that structure, you still can make decisions. Okay, so like the Rijksmuseum, for example, decides to follow, the law and Article 14 and develops a policy on, digital reproduction of public domain materials that makes it clear that you can use it, that everything remains in the public domain. The National Gallery, as we've seen earlier, goes for a, quite inaccurate and also restrictive approach of, claiming copyright over public domain reproduction. And then you have this kind of middle ground cases like the Fitzwilliam Museum, which claims copyright, perhaps, not on very solid grounds, but then distributes under an open license. And on that point, I also, that's particularly for the cultural heritage practitioners in the room, I wanted to mention a study we published actually the week after we had the webinar with cultural heritage practitioner, which is all about that. So it's all about open licensing models in the cultural heritage sector. So, if you are, for example, thinking about your own policy as an institution on how to distribute, whether and how to distribute digital reproductions of your collections, openly, you can find quite a lot of useful information there. And then the second set of things I wanted to highlight are about use. So we talked so far about subject matter. Again, I'm trying to kind of go through a traditional thought process in copyright law. First, you establish whether what you're dealing with is protected by copyright. And then if it's protected, okay, the next question, if you are a user of copyright work is, can I use this or not? And that's, what Anthi covered and also Konrad earlier. There are various options to use works lawfully. But if we look at those options, like in relation to these cases, again, the left-hand side case is very straightforward. It's public domain, it's a public domain painting, and the digital reproduction is in the public domain. You can use it for any purposes. Second one is possibly from a use point of view is the most complicated one, because again, we don't know about the statute itself. It may be in copyright, so it may qualify as an orphan work, which again has got its own route under EU copyright law to use it. But then the photograph itself, again, it's in copyright. So, but in this case, I think rights clearance is probably a viable option. I mean, you have enough information to get in touch with the copyright owner. You have the institution holding the photograph. You have the name of the photographer. It's probably a fairly viable option. And then in the third case is again quite straightforward because it's distributed under a Creative Commons license. And that's the good thing of Creative Commons licenses, and more generally to use things with permission. They're clear. What that license says is, yes, you can use it for any purposes, including commercial purposes. You can modify it under the only condition of crediting the author, in which in this case I'm guessing will be the Fitzwilliam Museum. I'm not sure. And so on that, I also wanted to connect to another resource I mentioned in another one of the previous webinars where I participated, which is the Europeana Classroom. So basically, if that's your approach, you want to be safe, okay, you want to use things that I know I can use, there are a lot of resources out there. So there are, things you can do under the licensing schemes that your institution subscribes to. And then there are a lot of resources that are openly available under Creative Commons or similar licenses, like Europeana Classroom is one of them. It's a portal where you can find open educational resources distributed under Creative Commons licenses. So, yeah, and if you're looking for inspiration, you need to fill a slot in your teaching schedule, and you're looking for something. There's a lot of materials there. But then, and that takes me to the second main point I wanted to make. Of course, what's already available and covered by a license doesn't necessarily cover what you actually want to do. Okay, so especially as a teacher or as a researcher, you may well want to use something that is not on Europeana Classroom or is not covered by an existing licensing scheme. And maybe, rights clearance is not a viable option because you want to use a lot of different works, or, the thing you want to use is very obscure and requires a lot of research and you don't have the time to do that. So that's where, having a comprehensive view of the law becomes really important. So again, I'm just connecting to things that have already been said, but it's where it becomes important to know and be aware that, using works with permission, with a license or through rights clearance is one option, but there are also, as we've discussed, several options to use them without permission. Using works without, that are out of copyright is one of them. We discussed that. Or using works under exceptions is another one. And so again, I did promise I wouldn't give you much more information, but I did want to list just 3 exceptions, which I'm not sure have been mentioned yet. Also because I think, given the audience of this webinar, cultural heritage practitioners, educators, and researchers are particularly relevant. And again, sorry, I didn't said, but all these slides I'm including here are either the copyright directive or copyrightuser.eu, which is an open access portal providing guidance on EU copyright law. So everything I'm saying, you'll find information about it there, including on exceptions. So the 3 exceptions I wanted to very briefly mention are text and data mining for the purposes of scientific research. So there is an exception in all EU member states that allows you to carry out text and data mining for scientific research purposes. So if you're a researcher, what you want to do is, for example, identify patterns across a large corpus of journal articles or images. In principle, you can do that under certain conditions. There is also another exception present in all member states about educational uses that is supposed to enable cross-border teaching activities. So it's important to be aware of that. And then also for the cultural heritage practitioners in the room, there is an exception that allows you to create copies for preservation purposes. Again, we don't have time to address any of these in any sort of meaningful detail, but the 2 details I just wanted to share about them are first that they are mandatory exceptions, meaning that unlike other exceptions that have been introduced in EU law in the past, member state must and have, I guess, to a large extent, implement these exceptions, so they should be harmonized at least to a certain level. And the second one, as you can find in the common provisions in Article 7 of the directive, is that any contractual provision contrary to those exceptions, exactly those three I showed you, are unenforceable. So, which basically means that if a contract, like the terms and condition of a service you want to mine or use for educational purposes, prevents you from benefiting from the exception, then those terms and conditions are not enforceable. So you can rely on the exception. The exception prevails. Right. So I'm conscious of time, so let's jump to what I think are the key takeaways. So I've tried here to focus on takeaways that are not really copyright specific. I mean, are about how to think and deal with copyright law rather than details of the law. And the first one, which I tried to convey earlier, is that really my tip is to start from your own need. So as I said, decisions, as you've seen through these presentations, are structured by copyright law, but they're still your own decisions to make. Okay, so the one example is how to distribute a digital reproduction of a public domain work, or how to use something in the class and so on. And my tip here really is to begin with your actual need, whether that's your public mission as a cultural heritage institution, your educational goal as a teacher, or the specific purpose of your research. Start from there and then work out the copyright aspects rather than the other way around. Like, shouldn't be that copyright drives your research or your teaching. Quite the opposite. And the second one, which is related, is really try to instigate some positive change wherever you can. So some of these decisions I just mentioned will fall within your own autonomy as an individual, so what to show in the classroom and so on, whereas others will be shaped, and constrained by, institutional policies, legal frameworks, or external policies of, a publisher, for example. If you want to use a third-party image in your journal article, the policy and the terms and conditions of the publisher will matter, of course. But here the tip is, where the law or the policy does not allow you to achieve your goal, as a teacher, as an educator, a researcher, or cultural heritage practitioner, then try to shape that in your favor, try to shape it positively. And the third sort of horizontal tip is, to be able to do one and two, you need to stay informed. Because something that I'm sure will have become clear throughout this presentation is that copyright is complicated and open to interpretation. And as with any complicated things, is not something you learn in one day, put in the bag, and know it for the rest of your life. You need to kind of continuously engage with it. And there are several ways of doing it. One is to attend, this webinar and initiatives like this. There are online resources out there like copyrightuser.eu, which is kept up to date. So that's a reliable source of information. And also I wanted to point you to the Europeana Copyright Office Hours, which the Europeana Copyright Steering Group regularly offers, particularly to cultural heritage practitioners, but they really touch on topics that are relevant for educators and researchers as well. So yeah, you can subscribe to the mailing list and keep up to date on that. And yeah, with that note, I'll conclude. Thank you.
Okay, thank you very much, Bartolomeo. We can have a small break of 5 minutes, and we will be back with the presentation of René Habermans on the Out of Commerce Works portal. Thank you. See you in 5 minutes. Okay, I think that we are all here. We can start the last presentation of René Habermans. Welcome, René. The floor is yours.
Thank you very much. Let me just share my screen here.
Of course.
Okay, share. Okay, I think you should see it now, right, Daphne?
Yes, yes, perfectly.
Okay. Okay, thank you very much for inviting me. I'm René Havermans. I work at the EU-IPO, that's the European agency for basically what was for trademarks and design registration, and we have opened also an observatory 10 years ago. What do we do there is to combat counterfeit and piracy together with different stakeholders. So we create networks to minimize that effect. Okay. Shortly, we'll also start with a new copyright center. This initiative will be launched in November this year, where we will compile everything what we do regarding copyright. So you want to pay attention to that as well in the end of next year, of this year and next year. I'm particularly involved in the Out of Commerce Works portal, as well as the Orphan Works portal and Agorateca, so a couple of copyright tools. And today I just want to give you guys an update about where we are with the Out of Commerce Works portal. You already had a presentation about this from my former colleague, Juris Ivans, who went back to the Latvian library. So I'm not going to repeat everything he said. I just want to give you an update where we are right now, but just to give it a head start. So for those who didn't see the second webinar, so this I can skip. The Out of Commerce Works portal has actually several users. So we have the data providers that are the cultural heritage institutions, archives, and the like, that will create, modify, delete records. They can perform searches, and so we have the national authorities. So basically what they do is to approve new users. We don't do that ourselves. In some cases we do. When a member state doesn't have a contact person yet, then we try to evaluate if this is a legitimate user. Then we have, of course, the rights holders and just the public itself, because everybody can have access to this portal, not as a registered user, but you can still do some searches and see what's inside this portal. What we do not store, by the way, is the works itself. It's just plain metadata. So if a library wants to digitize and make available any work on their website, they first have to, and they apply to the Out of Commerce scheme, then they have to first register it in our portal and leave it there at least 6 months, so that any user can opt out if they don't want to be participating in this portal as a whole, so a general opt-out, or they want to opt out for a specific record. Now, this is a bit how it looks like. The first portal release went live in 2021, so already a couple of years back, but we are doing a lot of new developments now, so in a few slides I will get back to that. So how can you create a record now in this portal? You can do it in 3 ways. The most simplest way is just to go to the user interface and just create one particular record at a time, where you have to fill in some fields and some other fields are optional. Then another feature that we have is an Excel bulk upload. So this is basically done for a couple of 100 or 1,000 records at a time. What you do here is you download an Excel file. It's a template. You fill it in, you upload it again to the portal, and everything goes right. Then it will be registered in the portal. So that's the third option. The second option. To the third option, I will go in a little bit. So if you have registered your records, this is a bit the page where you can see the information that is then provided. So it gives you an ID number, a title, for which category you have registered your work, and some more information. Now, the third option to upload data is via an API. So this is what we developed basically this year, and that went live a few months ago. What you see here is a bit of a timeline of the development of this year. So you saw in the first half of this year, we created this API, and we also did a big redevelopment of the search and alert functionality because these were not performing optimum, and we had a lot of requests to improve them. So this is what we did. And then from now until the end of the year, we are reshaping the opt-out functionality and also improve what we call user management. I will get back to that as well in a bit. So let's first see the API. We started with the creation of an API so that you could, let's say you want to upload like more than 20,000 up to whatever. I mean, there was no limitation there. It connects to your database, connects to our database, and then once you have set all the parameters, it's more or less automatically pulls all this data into our portal. This was tested with the National Library of Germany, and it works well. I mean, there are more organizations now using it. Basically, most of them are from Germany and from the Netherlands by now, but I can imagine that more organizations will use them, especially when you're talking about national libraries or national archives where they have a lot of different work. So you can not only upload all these records, you can also delete them, change them, download them. So there's a lot of things you can do there. There was a specific page regarding APIs that gives you all this explanation in case you want to use this feature. First of all, you have to sign up for it, and then the system will guide you through the steps that you have to do. And we have a specialized IT team that can help you in case you have problems or you have particular questions. Now, we also improved the search functionality. So we have basically two search functionality, a basic search. You just want to quickly see what records are registered in the portal if I type in a certain title to see if, let's say you have a title blue, let's see all the records that come on your screen, and you can also download them if you want to. I think the more interesting option now is that we have this possibility that you can add logical operators, like saying, I want to have a title blue, but with an addition, and it wants to see that it has been registered in Germany, for instance. So you can build your query there with a lot of different options. I suggest that you just play around with it and see what pops up. So this is quite a big improvement because a lot of users had the issues that they could not find back certain records because it was a bit messy in the beginning, but this has been a big improvement. And linked to that is the alert functionality. So when you set a certain search query, you want to see, okay, this is the situation right now, but I want to receive an alert when the situation changes. Let's say you're looking for a particular title, it's not there, but you say, okay, I want to be informed once this title has been created in the portal, and I want to receive an email about it so I don't have to go to the portal every time to see if it's there or not. So this is linked to this advanced search option, and you can set different alerts for that. For instance, I think you have a limitation up to 10 or 20 alerts at a time per user. And you can also install the frequency when you want to have an update. So it can be on daily, weekly, monthly, as you like. You can delete your alerts, you can edit them. It's very user-friendly. Now, what I mentioned before, we are reshaping the opt-out functionality. And why do we do that? Because we have, now that we get more users in, we want to protect the maluse of this portal in case that happens. So there is a validation cycle inside this portal. Somebody wants to opt out as general or specific work. This becomes active, but the CHIs can always say, I want to have more information. What is this about? I'm not sure if this is a valid opt-out, and then they can actually deactivate it if they want to do so and get in contact with the person or the organization that's opting out, maybe to ask for more information and then activate it again or not. So we want to make sure that we have a clean database with clear responsibilities. So we as an EO-IPO, we don't have any view on if an opt-out is legitimate or not. That's up to the register users to determine, because they know the users better than we do. We just provide the portal as such to make this environment possible. Then a huge difference is that we added 3 new fields to the portal: edition, volume, and issue, because that was highly requested by some users because they didn't know where to provide this information. So they squeezed it somehow in the title or in the description of a work. But these new fields have just been added, and that has an impact on the extended template. We have 2 templates, so a standard template and extended template. If you want to use the extended template, just make sure that you download the recent version, because the old version will not work anymore. Okay. Now, what will come into play later this year, and I'm currently testing this, is that the Excel bulk upload gave a lot of problems, because normally when you register something in a portal of a certain organization, you have to do it online. In our case, and that's quite exceptional, you can download an Excel, fill it in as you wish, and then upload it. But we have to somehow help the user how to fill in his Excel sheet. Although we have guidelines, we have a handbook, we have a lot of documentation, but as you know as well, you don't feel always reading through to all these guidelines. You just want to have it work. So what we built into this Excel sheet now is that whenever you make an error, the Excel sheet immediately says, up, you have an error there, and you should maybe do it like this. So before you start uploading something, you're almost about 99% sure that the Excel sheet that you want to upload is going to be accepted by the portal. There are some cases that cannot be built into this Excel macros, and that's, for instance, regarding duplication criteria. Let's say you want to upload a record that already exists in the portal. This can only be determined once you upload this Excel, because then it looks at the portal itself and says, oh, wait a minute, there's a similar work of the same user with the same internal ID. This is a duplicate. This is not accepted, so it will bounce back for this particular record. The rest will be accepted, but this one will not be uploaded. And then last but not least, what we foresee for next year, we will improve the user interface because there are a lot of improvements to do there. We will also visualize basic statistics, because they are not there yet, just so you can see how many records have been uploaded and things like that. So this will be available, and we will also improve our tutorials, frequently asked questions, manuals, and things like that. So that was very short, Daphne. I just wanted to stick to the 10 minutes. Back to you. Thank you.
Thank you very much, René. There is one question for you. Can you specify the main methods by which libraries identify OOC books?
No, that is up to the library. I mean, libraries and archives, they make their own determination about what books or titles or photographs they will upload. And that depends on their legislation in their particular country. We basically accept everything that's uploaded. I mean, we don't make a filter or a investigation if this is conforming their national legislation or European legislation. The portal just accepts it as it is. And of course, everybody can say, well, this has to be opted out or not.
Good. Thank you very much. There are also other questions in the chat where I can see Eleonora Rosati has already responded. So in any case, we will share with all of you, with all attendees, the presentations used and also the chat. Also, the video recordings will be uploaded to the project's website. So very shortly, you will also have the opportunity to see the recording as well. If there is no other question, I would like to thank you all for your contribution, for your attendance, and hopefully we will have another webinar very soon regarding copyright law. Thank you very much. Have a nice day ahead.